I think we'll just, obviously there's only a few people just joining, coming back in now.
Now, press the wrong button. Hang on. Yeah, it's all right. Yeah, we're getting there. Welcome back, people. We'll start in a couple of minutes.
I do think it's interesting how you can't see. Oh, yeah.
No, it's just stressful not being able to see all your. How many of you lot are here now? I'll keep pressing the wrong button.
15. There's 15 I can see. Still popping through.
Yeah.
Yeah, it's jumping up quite fast now.
All right, for those who just joined, we'll go in a couple of minutes. People will still be finishing off their lunch, I suspect.
Yeah, it's only just gone 2 anyway.
Right, as I said, well, we're going in about a minute. Just bear with us, troops. Okay, right. Welcome back, everybody. Thank you for rejoining us. It's always a concern that nobody's going to come back for the second half. So we're delighted you could join us. People raised questions earlier. I think most of those are going to be covered this afternoon. There was one answer I gave which was wrong, which I'll put right in a second. Thank you to my friends who messaged me during the break. In answer to your questions or comments, yes, I have got jeans on underneath this. Yes, I have got a new sit-stand desk. No, we're not going to the pub afterwards. Thank you. I don't think I look like a pilot. And yes, Bukola is much, much better than me. So-called. There's mates for you. So the question I got wrong was somebody asked a nice question about the strategy, the resident strategy, and the needs to share it with residents over 16. And I thought that you were going to have to try and find out subtenants. No, that's not right. If you look at the definition of what's required, and I think it's section 91, it's residents over 16 in units that you manage, or it's the owner of any other units. So apologies, the little answer I typed out was wrong. You won't have to find out who your leaseholders subtenants are. They're the owner, so you can just give the strategy to them, and it's for them to, if they want to, then pass it on. So I hope that clarifies that. Bookie, I think it's going to be over to you, but I've messed my screen up again, gone the wrong way.
If you just go on to the next slide, please. Hello, everybody, and welcome back. Right, so we left off with the 87 Act, and now we're going to discuss part 5 of the Building Safety Act and the other provisions relating to safety itself. So I think that what we've tried to do here is pop in the most, well, everything's relevant, but the most relevant sections to assist. In terms of the wording of section 116 to 125 and Schedule 8, they were all introduced as a series of amendments on the 14th of February this year. So thereafter, should I say. Sections 117 to 120 are the key to sort of tracing how the protection is available to leaseholders. So again, if you again, that's that those sections are of significant importance. Section 134, and as again, just to mention that as we say, the parts of the talk that are highlighted green are all in force now. So that's something that you can always refresh your memory with, just to remind you that it is the green sections. So section 134 and section 135. Now, these are duties relating to dwellings, and they focus on the Defective Premises Act and the new duty which, if breached, it rises to a civil claims, and these civil claims can be brought by leaseholders as well as landlords. And I think Daniel's talking a bit more about that later on. Section 135 deals with limitation, and as you may or may not know, limitation was 15 years, but now will be 30 years. I think one of the questions actually that popped up referred to the limitation aspect. Section 146 and Schedule 11 contains provisions for regulations to construction projects, and sections 147 to 155 sets out liability relating to construction products such as cladding and costs for contribution orders. If we just move to section 157 and 159, that's all to do with professional development, architects, and their appeals committee, what have you, and that's all set out there. Danny, if you just move to the next slide for me, please. Great. Just, yeah, that's perfect. No, we've missed a slide. I think you've jumped. Just wanted to go a bit more into section 18. It might be after. You'll have to jump twice because that's just where I want to summarize. One more. Here we go. Yeah, and then we'll go back. I think it's better to talk about this here. Just in a bit more detail about section 116 to 125, which are remediation of certain defects. So it's the first section of part 5 of the Act. These provisions, is there a reason why they're not highlighted, Daniel? Are they why they're grey? It's all right, as long as everyone can see, but they are grey, just as an FYI.
I can't do it if it goes to the end of the slide, sorry.
Oh, okay, no, that's fine. So these provisions, they push away liability, and they basically save leaseholders from having to pay for works to put the defects right and any problems with the buildings. And they're contained in Schedule 8, as I discussed earlier this morning. Essentially, what they're doing, or what they're saying, is that some leaseholders will not be liable to contribute towards anything towards the defects. Some will be liable for some things, and some liable for the amounts as expressed or that are required in the lease. Sections 123 to 125, they essentially pull funds that would otherwise have been demanded of leaseholders, and they empower the court and the tribunals to grant an order against developers, landlords, and persons associated with those developers. So the orders may oblige those persons to carry out certain remedial works or contributions towards the cost of the works. In terms of the building liability orders, which I know is not on this slide, but it's just important to mention here, it's section 130. That expands liability from companies to associated companies. So, for example, company A, who is like directly liable for the defect, it can pass to company B, who was associated with company A at the time. So that's important to note. Daniel, you'll now need to go back 2 slides, I think, because we jumped that, and I think it's important that we talked about that here. And then just one more. Fantastic. So just to really summarize on limitation of service charge. So qualifying leaseholders, we talked about that earlier on this morning. The nature of the building, so 5 stories or 11 meters. It has to have been their home of the 14th of February this year. And the protection applies to all subsequent purchase of that home. Freeholders cannot pass on costs of cladding if linked to the developer. And if the developer is not paying and the owner not required, there is a cap on non-cladding issues, £10,000 outside of London, which can be spread over 10 years, and it's 0 if the flat is worth less than £175, 75,000, should I say, not pounds, and that's outside of London. Next slide, please, Daniel. So innocent freeholders can apply to the building safety levy for cladding. The building safety fund for buildings over 18 meters, non-cladding, so therefore wealthy owners cannot recover costs if net worth is more than 2 million for each building that they own, and it includes costs such as waking watch. So any monies that have already been paid count towards the cap, and shared owners are covered on a pro rata basis. That really sort of encapsulates those limitations of service charge.
Yeah, there was a question came in about building safety funds and the I think for registered providers. The problem you've got with the building safety fund, which was the first one that came in, which is the government money, which is available, is basically as a registered provider you can apply, but you've then got to say to them, look, we need the money because otherwise we're going to go bust or we can't afford it. I've slightly over exaggerated the wording there, and they do expressly say, well, if you apply, then we're going to speak to the regulator of social housing about you. So the building safety fund is tricky for registered providers. It's going to be easier for you to go for the building safety levy, which has now been extended to all sizes of buildings, in fact. And that's the money that's coming from the developers who've been basically forced with thumbscrews by the governments to cough up and chip into this building safety levy fund. So I think as a registered provider, you're going to have much more opportunity to go for the levy rather than the funds. And you're not subject to the wealthy owners tests.
If you, I was going to say this too. If you jump over the next slide, then that will be your next slide to continue.
Okay, thanks,
right?
Bookie. So, right, remediation, carrying on from where Bukola's just been talking. These regulations are quite recent. They came in July. So they're snappily entitled Building Safety Leaseholder Protections (brackets England Regulations 2002). That's a link to find them. So this does various things, and one of the things that it talks about is that if all the leaseholders have got together and bought the freehold, so collective enfranchisement or common hold type scenario, common hold is different, so you don't have leaseholders in common hold, but that scenario where the leaseholders all together own the building, then those are excluded from this these sort of protections. But there's got to be a calculation of the net worth of not just the landlord, but all of the groups of companies in the landlord group. So a lot of the developers will, of course, develop a building through a subsidiary company. So just to pick on Barratt Homes, you'll have Barratt Homes Mansion House (brackets Limited), and the next scheme will be Barratt Homes Festival Road Limited. So the calculation what has to be done of the net worth of the whole group. And they're trying basically to stop rich companies getting service charges back from your leaseholders, which could be you yourselves or your subtenants or whatever, when looking to recover the cost of remediation work. So the sort of things like moving cladding. That's not just cladding, it could be cavity walls, that sort of stuff. But so they're going to have to certify how much they're worth, and also there's a formula for calculating the value of the lease, because some leases are not worth enough that they can be forced to pay the money. This is the certificate that you won't be able to read, and I don't like putting stuff up that you can't read, but I just wanted to show you, because this, I say this is the certificate, this is the first part, I think about 5 parts of the certificate. So when you're going to send out a service charge demand, or when this head freeholder is going to send out a service charge demand, it's going to have to send out one of these certificates every time it wants to try and recover remediation costs through service charges. So I'll read it for you. The certificate relates to the lease of, and it gives you the building, the date the lease was started, the flat number, name and address of the landlord, when the lease was granted, name and address of the current landlord, name and address of any superior landlord. So all of those have got to go on. We haven't finished. Then we go on to the questions as to the net group worth. Now, basically, all of these questions are going to be set, so the answers apply as at the 14th of February 2022. So you've got to do the net worth of the group, and then the number of buildings that the group owns. You have to say whether or not they're worth more than sort of £2 million a block. Then there's questions for the landlord's developers as to what the works are going to be, who was responsible, whether none of them were responsible, question about the works that have been done, how much was paid, is there a connection between the leaseholder and the developer, how much has been paid across. Then there's more certification. You've got to set out all of the companies in the group. You've got to set out all of the company accounts. You've got to find a certificate from the chartered accountant to produce to say that the valuation is right. You've got to set out details of who carried out any works, details of any joint ventures, provide evidence of the works that were done, evidence of what's been paid, what could have been recovered from other people, what percentage the landlord owned, pictures of all of the landlord's organogram, one of these lovely little pictures, diagrams as to who's there. Then you've got to certify that. And then there's definitions. So that certificate's going to have to be done every time you ask for service charges for remediation works, or somebody asks you for service charges for remediation works. There's a lot of information that needs to be done there. Now, on the whole, that only needs to be done once, but if there's any change, or the lease is sold, or there's any change in the structure of the companies, that's going to have to be a new certificate done. Or if there's new remediation works done, then all of that's going to have to be done. So it's a big, complicated certificate that either you lot are going to have to do, or you're going to have to check when that comes in and is served on you as, say, a head leaseholder. Probably going to be on one of these modern blocks where you've taken a head lease from one of those developers. So get used to those forms, because you're going to start seeing those coming in. Bukola's already mentioned some of the other stuff that is coming in part 5. Building industry schemes. The idea is there's going to turn the building industry to something more reputable. Whether the government sees it as a bunch of cowboys, I don't know. But we're talking about a scheme to introduce building safety. There's not been much detail coming out as to how they're going to do that yet. So we're some way away from that. One interesting thing is that the government's got the ability, so you'll see this is a white heading at the top, prohibitions. This isn't in force yet, but the ability to ban people. So they can introduce regulations preventing certain people developing. And this is sort of, I think, one of the sticks that they were using to beat the developers. When they were going around saying, oh, we cough up tens of millions of pounds for the building safety levy, there was a suggestion that if people didn't, then they could be banned from doing further development works. And that's power is under section 128. Now, we haven't yet seen those regulations. And once those regulations are in force, we don't know how aggressive they're going to be about trying to stop people from doing further development work, but that ability is there. On a similar line, they've got the ability in the future to ban people from being involved in building control. So presumably, if somebody has signed off in the past a building as being safe and it wasn't, and I think you can sort of think about a couple of buildings, or one in particular where they may be looking at people who signed off building control on that, they will have the ability, when they bring in these regulations, to ban people from doing further works and further being involved in building control. So situation now is where we want to try and recover some costs of, let's call it cladding. It's not just cladding, but that's the most common example. Can we recover it from a company? Turns out that company is pretty much just a shell company and hasn't got much money. And to a certain extent, that's why they set up these small shell companies. So under Section 130, the High Court, so that's the level of court above the county courts that most of you deal with, the High Court will have the ability to make a building liability order against associated companies. Now, on the face of it, they don't have to have done anything wrong. We haven't yet seen all the details as to how this is going to happen, but it looks as though they will be able to say, you are just a sister company. You were set up by the same owners. You may have had nothing to do with this building in question, where there's lots of costs being incurred in removing cladding or putting right structural defects, but we're going to make you pay. So it's quite unusual, because normally one company is completely separate from another company legally. They have their own legal identity, and you can't just say, well, you've got a similar name or you're owned by the same shareholders. So this is an attempt to get around people setting up small shell companies and avoiding liability. Section 131 does define associated companies, and it's quite wide. The other thing is you're entitled to basically cross-examine the other companies and say, right, well, who do own you? Who are your shareholders? Who funds you, etc. So you can see if they are associated companies and could be held liable, because they were obviously concerned that companies would just go, don't know, mind your own business. We're not answering any questions. So that there is the ability to get an information order against associated companies with a view to asking them to cough up for their sister companies. A little bit more on service charges, some more detail on what Bukola added on our excellent stuff on service charges. Section 20 is the consultation that has to be done to residents, usually leaseholders, but it can be tenants and it can be shared owners, where you're planning major works or long-term qualifying agreements. So qualifying works, qualifying long-term agreements, you have to do Section 20 consultation. I suspect most of you have heard of this. This is in white, so it's not in yet, but regulations can be introduced to amend Section 20, where before you can consult, you're going to have to set out in that consultation what you have done to try and get some money back for your leaseholders. If you're going to ask them to cough up service charges, what have you done? So have you tried to get grants from the government? Have you sued third parties? Have you considered suing third parties? Have you made a claim on buildings insurance, etc.? They're going to expect you, and we've yet to see the details as to quite how much you're going to have done, to have tried to get back some money. Now, certainly we as a firm, Roythornes, have had lots of inquiries, can we sue our architects? Can we sue our builders? And it's a difficult, tricky question. I'm sure some of you are aware that there was one successful case made recently, quite a high profile, about 4 months ago. That was really done on the construction of the contract between them and the builders. But yeah, so you're going to have to have looked at these things before you can do your Section 20 consultation, and you're going to have to put that detail in. Similarly, if you're a head leaseholder and the developers are asking you for some money, you will get some protection back under this. Okay, let's have a quick look at the question that came in. Does the building safety levy or fund cover costs related to compartmentalisation? Yes, it does. Okay, right. So Defective Premises Act, Bukola mentioned this was there. So the Defective Premises Act has been around for ages. It's been strengthened. It's been given a bit of oomph. So where you're carrying out works on a building that consists of dwelling, so it has to be residential, or part of a building that's residential, you now have a duty to see that work is done in a workmanlike, or as the case may be, professional manner, with proper materials, and so that as regards the work, the dwelling is fit for habitation when the work is completed. Now, you would sort of hope that you weren't generally doing works that made things that weren't fit for habitation, or you weren't being workmanlike, or you weren't being professional, your contractors weren't being workmanlike or professional. But just for the avoidance of doubt, it's now clear in the Defective Premises Act, that's what you've got to do. And you have got a duty to do that and make sure the property is fit for habitation. Now, there is a defense available. The big boy told me to do it. Well, in this case, you're a subcontractor and your main contractor told you to do it, but it has to be specific instructions. That is exactly, I did the work in exactly the manner they told me to. So if you have a discretion as to how you carry out the work, then that's not a defense. But if somebody has told you to use specific material, do it in a specific time frame, etc., and you've got a written contract on that, it doesn't say in writing, but you wouldn't want to try and rely on this defense if you didn't have it in writing, then that's okay. That's a defense to a claim under the Defective Premises Act. Again, one of the questions about the limitation period. So a limitation period is set down by government as to how long you have to sue someone, to bring a claim. There's a reason for this. They don't want claims hanging over people's heads for years and years and years with all the stress this causes. And also they don't want people suing somebody decades after the event when the person they're suing has no recollection of what's going on. I mean, I can't remember what I was doing yesterday, let alone 6 months ago, let alone 6 years ago. So there's a good reason why we have limitation periods. Oddly, they vary from case to case. If you want to sue someone for slander or libel, you've got to sue them very quickly. You've got 3 years for personal injuries. Most breaches of contract are 6 years. Claims under a lease are generally 12 years because they're sealed under a deed. I don't quite know why they gave you longer for that. But if you're thinking of suing somebody for a defect, quite often the works that we now know were defective were some years ago. The cladding that was put on, the compartmentalization works were done 15 years ago. On the face of it, at the moment, or until recently, too late. You should have sued them earlier. You can't now try and recover your costs of putting it right or any other losses you've suffered because it was too late. So that's now been extended massively. You've now got 30 years to sue someone under the Defective Premises Act or under the Building Act 84. So that's the longest limitation period we have in this country. So they want to make it very clear that you can still sue somebody. Now, if the company who did the work's gone bust, it may still be too late. You'd have to find out if they still have valid insurance for that. So it's massively extended that. So in terms of the question that was asked, what impact's that going to have on us as a registered provider? Well, potentially it makes it easier for you to sue the company that did the works on your building many years ago. Of course, if it was you that did the works yourselves, then it makes it easier for someone to sue you. So it does have a big impact. And if you think you could be sued, you need to be talking to your insurers fairly promptly if you haven't done so already. Okay. Now, people will often say life's terribly unfair. This is all breach of my Human Rights Act. I know the Daily Mail gets particularly angsty about the Human Rights Act, but you won't be able to say this is outrageous. I've been sued for something I did 28 years ago. I have no recollection of it. I shredded all my documents 15 years ago. It can't be fair for me to be sued. So Parliament has expressly said you can't rely on the Human Rights Act as a defence to a claim under the Defective Premises Act or the Building Act because of this. And Parliament is allowed to do that. Although it's passed the Human Rights Act in the past, it can create exemptions, and it has created an exemption. So you can't now go, this claim is unfair, breach of my Human Rights Act. Doesn't work. That's in, by the way, the Defective Premises Act, that was in green. Something else that's potentially coming, looks likely to come, is the New Homes Ombudsman, which has been suggested under the Act. Now, there is sort of a version of this that's been set up recently, but that's actually been set up basically by the developers themselves. Whether that's the one that will be adopted, but sections 136 to 143, so there's quite a lot of the Act goes to this, allows for the establishment of the new Homes Ombudsman, and the creation of a developer's code of practice. Now, so what they're trying to do is do this on a voluntary basis and set up their own version before it's forced on them by regulation and by governments. The Ombudsman will have power over new build home warranties. Most of these new build properties come with, there's two main companies that do it, sort of a 10-year guarantee. There's been concerns that they're not quite as great as they're made out to be. So the Ombudsman will have the power to oversee all new build home warranties and basically force people to offer good warranties. So that's to come. As I say, the developers are trying to create their own version, and that may be adopted by the government in due course. I don't know. Something else that Bukola mentioned is changes about construction products. Sections 146, Schedule 11 of the Act. So this is one of those bits of law that's in, but subject to further detail. So we've still got the regulations to come in for exactly this, but the government's going to have the ability to ban products. Now, those of you who have, of course, been following, perhaps reading Inside Housing and the excellent articles they've written on Grenfell and the inquiry there are some products that frankly shouldn't have been used. Some of the sales descriptions were misleading. Some of the tests were pretty bloody useless. So the government's going to have the ability to ban products which it regards as being unsafe, or it can restrict their marketing or supply. So you can't claim that. You can't sell it to those people or for those types of buildings, etc. It'll have the ability to introduce designated standards, which sounds a great idea, but designated standards will be difficult to enforce to get the detail right. But that sounds a good idea on the face of it. Sections 147 to 151 creates liability if you fail to comply with a requirement that's imposed in respect of construction products. So basically, if you're using construction products that don't meet the designated standards or have been banned, etc., or if you're selling it and you make a misleading statement about it, you can be sued for it. Or if you're just manufacturing something that doesn't work, you can be sued for it. Now, they probably didn't need that bit in, because if something is inherently defective, there's usually an implied term into it. But of course, commercial contracts will have limitations of liability, etc. But yeah, so that's all coming in to try and stop some of the cowboy construction companies or the slightly dodgy salesmen selling things that frankly don't work. More on that. What can we do for stuff that's already happened? So those regulations will apply to sales, products put in the future. What can we do for past? This is just about cladding, this little section, section 149. If it was not a compliant product or somebody made a misleading statement, and I think you can see there's going to be some claims made along that because some of the sales material was frankly rather misleading in my humble opinion. I know others will argue against that and there'll be defences put into claims, or they were inherently defective, which causes the building to be uninhabitable because people can't be expected to live in it because it's too dangerous. Then the salesman or the manufacturer will be liable for any economic loss. Now, so normally, if somebody sold me some dodgy cladding and I've had to rip it off, I can say to them, right, I'm suing you for the cost of taking the old stuff off and the cost of putting the new stuff on. And I can win my case for that. But in the meanwhile, I might have an empty block of flats and I'm losing a whole lot of rent. That's called economic loss. And now this has made it clear that I can sue them for that as well, not just the materials and the cost of putting it right, that I can sue for economic loss. So that will massively increase the potential amounts of claims that are brought for cladding defects in the past. Again, there may be an issue that the company that supplied it may have gone bust, etc. But we'll see. That sort of leads on to cost contributions orders. So if somebody's been convicted for failure to comply with the requirements about construction products, then you can go after other people. So I jumped too fast there, in the group to cover the costs. So if they've got sister companies that have gone bust, you can seek cost contributions orders, or from other parties who were involved in the transaction. Okay, right, moving on to one of my exciting things I get very excited about, fire safety. So this comes in through section 156 of the Act. And the regulatory reform fire safety order will be amended. This is in orange because this is coming in start of next year. I'm delighted to say that there is now going to be a requirement that anyone doing a risk assessment must be competent. Now, you might be laughing at that, go, well, of course they would be competent. But in my humble view, and the humble view of people who know much more about fire safety than me, there's a lot of people out there who frankly weren't very competent in doing their fire risk assessments. Yeah, I've done my 10 years in the fire brigade. I'm signing myself off as an assessor, despite having no technical expertise on that. So anyone now doing a fire risk assessment from January next year will have to be competent. Thank the Lord for small mercies. If you were doing an assessment or you were involved in the assessment and are now leaving your job, you are obliged to hand over information to the new employee or the new company that is taking over responsibility for fire safety. Because what was happening was people were saying, yeah, we've got this information that might be useful for you, but you sacked us, so we're keeping it. So there's a statutory obligation that you will have to hand that over. And interestingly, because although this is amending the fire safety order, there's now direct overlap to the rest of the Building Safety Act. So anyone responsible under the fire safety regs is expressly required to cooperate with the accountable person or the principal accountable person under the Building Safety Act, which again, you would think is a good thing, and you would be worried if they weren't, but clearly the people haven't been talking to each other. So they are now told by Parliament, you have to. So those are coming in, and the Fire Safety England Regulations 2022 coming in January 2023. Now, these regulations are quite detailed, and I'm really only putting in a summary of the key ones here. So please, these are just notes for me to talk through and give you an idea as to the things to look at. This is not a whole list. I've got about 3 or 4 short bullet points when actually there's 20 or 30 things that you need to be reading. So please don't take this as a full list of what needs to be done. But in Regulation 4 of the regs that come in January next year, you're going to have secure information boxes for any building over 18 meters or 7 stories. It's got to be safe and accessible to the Fire and Rescue Authority. It's got to be in or on the building. In this box, you're going to have the name and contact details of the responsible person. So unfortunately, we've now got another title, but this responsible person was here anyway under fire safety regs, etc. So the responsible person, who's somebody at the landlord, the managing agent, etc., is going to have their name and contact details in this box. And we are literally talking about boxes here. All of the information that comes in Regulation 6, and we'll go to that in a second, has got to be in this box. The fire authority's got to have access to it. No use to them if they haven't got a key. Now, there are, of course, standard keys that the sector uses, and so I presume that you would want to use that. You can't put your own little padlock on with a 4-digit code and hope that the fire officer happens to know that your code is 1966 because you can remember that from winning the World Cup or whatever. That's not good enough. They have to have access at all times. So if you're not using a standard industry key, frankly, I think you're in trouble. That box must be checked annually. So you've got to check it's still in place, it still opens up, and you're going to have to check the details that are in there. So somebody in your organization is now got to diarize these and make sure that it's all being done annually. Okay, so this starts January 2023, not that far away. That's regulation 4. Again, I must emphasize that is me just summarizing a lot more detail in the regulations. Please don't take that as an exclusive list. Regulation 5 deals with the design and materials of external walls. Is it timber clad? Is it brick? Is it concrete? What's the cladding, etc.? That information has to be recorded for all of your tall buildings, your high risk buildings, okay? And you have to include in your any risk assessment you do, the level of risk you believe those walls and materials have for that block. I'm just going to have a quick look at the questions just in case. Will copies of the slides be available? Yes, indeed. Jan says that not sure that section 156 has an implementation date. If Jan says that, he'll be right. I will check and confirm that to everybody, but he'll be right. So regulation 6. Now, remember, regulation 6 information has to be put inside your safety information box that you provided under regulation 4. So for buildings over 18 meters, floor and building plans have to be put in. Hard copies in the secure information box. If you want to have an electronic system for sharing it with a fire authority elsewhere, for staff, for contractors, the local authority, etc., that's fine. But these regulations say you must have hard copies in the secure information boxes. So on the day of the fire officer can go in, open it up and go, right, okay, this is what the building looks like. And you might think, well, it's obvious from outside what the building looks like. No, it isn't. And there's a lot of information that goes in there, including floor plans with lifts, and fire information equipment. So for example, again, there's a much longer list of what you need. Where are the dry and wet risers? The fire authority needs to know that to put the bloody fire out and get the water up or get the wet riser working, okay? So if they're taking 20 minutes to find this stuff, no good, people are dying, okay? So all of that has to be in there. There must be a simple single page plan of the building. So limited basic detail, basically where the flats are, where the residents are, lifts, things like that. The floor plans are more detailed, single page plan of the whole of the building there, okay? Regulation 6 is one of the longest ones, and I've cut that down to 3 bullet points. Please don't take that away as you think everything in there. Regulation 7 deals with lifts and fire equipment in buildings over 18 meters and says if you've got lifts and fire equipment, which you frankly you will, you must do a monthly routine check of lifts, any evacuation lifts, any essential fire equipment, and you've got to keep records of those checks. Perhaps not surprisingly, if you find any faults with all of this, you've got to put it right. And if you can't put it right within 24 hours, you need to make a report of that. They don't expect everything to be working all the time, but for fire equipment, they expect you to do monthly checks and put it right within 24 hours. Whether you're doing this yourselves or through contractors is up to you, but you need to make sure that that's all done. Could be expensive. Regulation 8, wayfinding signage in buildings over 18 meters. This is basically evacuation routes and, most importantly, the floors, so the firefighters can know what floors they're on. You think, well, that's bloody obvious. I'll press the number 6 in the lift, or I go up and I count 1, 2, 3, 4, 5, 6. Not so easy when you can't use the lifts and when there's smoke and fire and things like that. So very important. So buildings must have clear markings of floor levels and any residential accommodation, and that must still work in low light or become visible with a torch. Okay. So that's about any buildings in 18 meters. Okay. Anything you build from now on or buy from now on, that's going to be required in buildings over 11 meters. So 2 different requirements there. Regulation 9. So this is not high buildings. This is any of your buildings with 2 or more residents, although it does expressly say if you've got a maisonette with no common parts, you don't have to do this. But where you've got a shared building with 2 or more properties, clear safety instructions displayed conspicuously about things like evacuation, about how to report a fire. So that's got to be on display. You've also got to give that to any new resident in the building as soon as possible. And that's got to be done within 12 months of the 23rd of Jan, 2023. So don't just think that these regs apply to high buildings. So we've seen 18 meters, some rules, we've seen 11 meters. Now this bit applies to any shared buildings. Regulation 10 and fire doors. If you've got more than 2 properties in a building with any common exit doors, you must provide information to the residents. Okay, so they must be told to keep the fire doors shut when not in use. I know you're going, well, of course we bloody tell them, and they don't listen. But these regulations are saying that they have to be kept shut. Yes, they will still try and prop them open when they're moving in or want to deal drugs or whatever, if you're a social landlord or a local authority, but they're not supposed to, and they must be given that information. They must be told not to tamper with self-closing devices. You're going, yeah, you're preaching to converted, Daniel. This is what we tell them anyway, but you're now expressly required to tell them. Residents must report faults to you. So all of that's within the regulations, and that information must be given to new residents who move in as soon as possible. To all other residents must be given within 12 months of the 23rd of January 2023. So you need some little leaflet setting out those requirements. And again, please don't copy those bullet points down. Go to the regulations. If you can't find them, we'll point you in the right direction. Get an explanatory information, get that out, and make sure you can show that that has been hands delivered. If you want to send it by email, put it on your website, great. But I think for something like fire safety, I would really want you to show that you have hands delivered that to all of your residents within 12 months of the 23rd of Jan, 2023. Bit more about fire doors. Buildings over 11 meters. So again, you've got to check, because some of this is 18 meters. This now we're talking about buildings over 11 meters. You've got to do checks every 12 months on front entrance doors to the flats. The doors from any common areas to the front entrance doors, okay? You have to keep records, including where the resident says, bugger off, I'm not letting you in. Mind your own business, I'm happy with this, or they're just not in. For buildings over 11 meters, you have to check communal fire doors. So not the front entrance doors to the flat, so any communal fire doors every 3 months. I suspect you're not doing that at the moment, but you're going to have to do that from January next year. And you must check that any self-closing devices are working. There is a reason why we have self-closing devices. They save lives. They might be a pain, they might go wrong quite often, but you have to check every 3 months that they are working. Okay, I'm just going to have a look at the questions because people tend to get excited about fire. Right, so there's a question about Fire Safety Act came in, and we're talking about the Fire Safety Act in a second. That's slightly different, okay? This is the Building Safety Act, Cheryl, that amended the fire safety regs. There is also the Fire Safety Act, which I'll look at in a second. Fire regulations for buildings only, or this is for all buildings. Well, each bit depends part to part. Regulation 8, new buildings over 11 meters, that's from January 2023, Sarah. Are there any recommendations about accountable persons monitoring the principal accountable persons? No, not yet. Somebody's saying I'm being a bit unfair on drug dealers. Yes, that's probably true. Regulation says plans and walls have to be shared with the fire rescue service electronically, and the chief officers are working on templates on how that can be done. Great, good questions, keep them coming. Right, Bookie asked about, mentioned the fact there's architects coming in. This bit's in, but the details not. So there's going to be regulations about architects and their skills and roles. People got very excited a few years ago about building safety managers. You're probably asking yourselves, why hasn't Daniel mentioned building safety managers? Some of you may have employed some building safety managers. Those of you who are too young to understand that picture, and the Norwegian blue dead parrot sketch, I don't like you because you're too young. It is no more. The building safety manager role does not exist under regulations. You may have people call that. You are not obliged to have building safety managers. Accountable person, principal accountable person, building safety manager, which was going to be introduced under the Building Safety Act, has gone, not there anymore, taken out. People felt it was too expensive, and generally building safety managers were looking to earn more money than your chief execs. Okay. So somebody, Cheryl, I think it was, asked about the Fire Safety Act. This is a different bit of legislation. Everything I've talked about earlier, Building Safety Act, this is the Fire Safety Act. Okay, this is in place. That also amends the Regulatory Reform Fire Safety Order. And so where there are 2 or more domestic premises, the order now includes, because it wasn't probably before and certainly wasn't clear, the structure and external walls and any common parts. And that includes doors or windows in walls and anything attached, such as, for obvious reasons, balconies. Okay, so they are now covered by the Regulatory Reform Fire Safety Order. There was arguments before. Fire authorities thought that they had responsibility for these and could monitor them, and the Fire Safety Order was not clear on this. It is now clear. That's been amended by the Fire Safety Act. So your doors and your windows are part of it, subject to the requirements for checks, etc. Also includes all doors between domestic premises and common parts, the front entrance doors. That's all now under the 2005 order. So that's great news, because one of the problems we had was getting this sorted. We, as the local authority, as a social landlord, would say, right, great, we quite understand that. We want nice new fire safe doors. Okay. The old ones were 5 minutes they were good for. Don't want those anymore. Made of plywood, go in seconds. Let's put some new doors in, and then the leaseholders would go, they're mine. I like that door. Don't replace it. I've already replaced it. You can't replace it, etc. And then the fire authority would come in, you've got to do it. And we were going, well, I don't think you can, because it's front entrance doors. So there was all this confusion. Now we know that front entrance doors are governed by it. We can impose or have standards imposed on us that they've got to be of a certain standard. But the question still applies, who's responsible for this? So you're going to have to go to the lease and look at the owner of the door or the balcony. Now, in most traditional local authority rights to buy leases, and therefore most of the leases that were done under right to buy, preserved right to buy, a lot of the social landlords who are stock transfers, they will have leases where the door is demised to the leaseholder. Sometimes you did daft things like keep the outside surface because you wanted to paint it, but the door itself was demised. So it's their responsibility, but you're going to have to check, and not every lease is the same. And some of your leases in your stock will be theirs. Some of the more modern leases, you will have probably retained the door. Some of them, they had the door when you had the glass and complicated things like that. But we can't be forced to replace the door. We don't have the statutory power to do that, even under the Fire Safety Act, if it's not our door. But what you can do is use the Fire Safety Act with the cooperation of the Fire Rescue Authority to get the door done. Now this is in place. For years, we've not been able to do that, but now we can. Section 3 of the Fire Safety Act also amends that. And I'm not sure how much it adds, but it changes the burden of proof to say if somebody's going to be sued or prosecuted for a breach of the order, it's now up to them to show that they've complied with the guidance. So any applicable risk-based guidance, if they can show they followed it, they've got a defense. If they can't show they followed it, and this may be you that's being prosecuted, then if you can't show you followed it, then on the face of it, you're in trouble, and there could be a prosecution, a fine, etc. Right. So I say any questions. Let's have a look. Apologies if I missed it. Can an accountable person be liable for anything that the principal accountable person is responsible for? Well, the way that the legislation's been drafted, potentially yes, you should be checking that they're doing it. But the clear inference is that because we've got the principal accountable person, that's who they're going to go after. But it doesn't actually say that the accountable person is not responsible. So that's the difficulty you face. I think that you would have a decent defense, but you don't want to be spending lots of money on lawyers. So yeah, you want to be, if you're an accountable person, but there is someone above you who's a principal accountable person, then yes, you would want to check that they're doing their duties. Oh, I know you can't speak out. Anybody got any other questions that they want to throw in before I close? We've got 5 minutes or so. So if anyone's got any more questions, do put them in. We will be sending out these slides. And if you really want to listen to me again, I believe we're sending out a recording of this meeting. Perhaps if you're struggling to sleep at night, you could play us again. Or obviously you're welcome to share it with colleagues. Otherwise, can't see any more questions coming in. Can I thank you so much for your time and interest in this? Do drop us a line if you've got any questions that come as a result. Bookie, do you want to add anything?
No, just thank you so much for listening to Daniel and a bit of me for most of the day.
Okay. All right. Thank you, everyone. It's been great. Thanks so much for your time. Cheers.
Thank you. Bye.